Hi everyone who is joining us. Thanks so much for coming out today to participate in Before It Becomes Urgent, how advanced planning makes long-term care easier. Before we start, I just have a few housekeeping items. There's a Q&A box at the bottom of your screen. If you have questions throughout the presentation, please don't hesitate to put those in there. I will be monitoring that throughout the presentation and we'll do our best to answer questions as they come up throughout the presentation. And just to keep everything on time, I'm going to introduce now from Zachariah Brown and Brackovich, two of our partners, Christine Brown Murphy and Colleen Brackovich. And then Ari Greenspan, who's the CEO from WeCare Healthcare Centers. We're sort of partnering on this. There's a lot of synergy between our two organizations, and we hope that you're going to come away with a lot of great information today. So without further ado, I'm going to introduce Christine. Take it away, Christine.
All right, thanks. We're really excited to be here today presenting to all of you. Carrie, is the format going to be that people can ask questions, or do we want to kind of hold those things off until the end? What are we anticipating doing here?
I will monitor the questions. So I think if there's a pressing question, we'll try to address it. If not, we'll get it at the end.
All right, perfect. So I'm Christine Brown Murphy, partner and one of the owners of Zachariah Brown Brackovich. Colleen Brackovich here, also another partner of Zachariah Brown and Brackovich. Elder law and estate planning attorney, is excited to be here with WeCare Centers and Ari to present today. I think initially we were going to be in person, but this time of year, I don't blame anybody for not wanting to come out of their warm spaces to hear us talk when we could do it from the comfort of our spaces online today. So we're going to try and dive into this information. And if you do have questions, please go ahead and put those in the chat boxes. And as Carrie said, we'll try to get to them as we move on. Ari, I don't know if you want to kind of introduce yourself before I get started and bore everyone to death, but why don't you go ahead and introduce yourself?
Sure. Thank you so much. I appreciate the welcome. Thank you, Christine. Good afternoon, everyone, and welcome. Thank you for joining us today for Before It Becomes Urgent, how planning ahead makes long-term care easier. We truly appreciate you taking the time to be with us. My name is Ahron Stark. I'm the CEO of WeCare Centers and Heritage Care Center in Squirrel Hill. Today's webinar is a collaboration with Squirrel Hill Urban Coalition, and it's made possible with the support of our partner and sponsor and the team here at Zachariah Brown and Brackovich. So Christine, I'm looking forward to sitting here and appreciating everything you prepared for us
Awesome.
today.
All right.
Go ahead.
We're going to get to work then. All right, let's do it. Okay, if I can get my PowerPoint to move for me. All right. So one of the things that this PowerPoint kind of discusses is the crucial elements that a lot of plans overlooked. Things like protecting your healthcare and long-term care decisions and making sure that we can safeguard your loved ones from unnecessary stress and expensive. What we're going to do is really teach you as much as we can in this time that we have together, how to devise and develop a clear plan so that it can give you peace of mind. We on a daily basis here at Zachariah Brown and Brackovich, we are dealing with families who are dealing with crisis. Maybe a loved one has fallen ill suddenly, or maybe they've received a diagnosis of a disease or some kind of ailment that is going to be progressive, and we know we need to begin that process of planning. So we are in the business of trying to help take away some of those stresses, provide some peace of mind so that you can put your attention where it needs to be, and that's on your loved one, supporting them through their journey of aging, and if it's an illness, that as well. So because we are attorneys, we have to issue a disclaimer, okay? The type of work that we do is really complicated. So for every rule, there is an exception. And for every exception, there is a rule. So be very careful. What we're talking about today is from kind of like the 32,000-foot overview of what the law says and requires and things to consider for your own circumstance. But it's truly tremendously important that if you have a need and you have concerns, that you reach out to our office and get specific advice for your specific situation. So whatever you hear today does not create an attorney-client relationship, okay? So this is our team. Carl Zachariah is the founding partner, and then myself, Colleen, Justin, Carrie, Erin, Melanie, and Katie Ann. And we all kind of have our specialties, but we don't do it all. You can't come to us for medical malpractice because we don't handle that. We are very much where we work with people in their estate planning through the continuum of life, from young people to planning wills and guardians, and then middle age where we're thinking about retirement, and then what happens if we get sick and need long-term care, and then we help wrap things up with estate administration. Okay. So today's topics are going to be the reality check, why elder law, estate planning matters, understanding the statistics of long-term care, essential documents. So this is really about where we are building a very comprehensive foundation. What is that foundation we need that as life changes for us, that we have the right things in place that are going to kind of adjust and work for us as we begin to move through the aging continuum. Asset protection strategies, trusts, transfers, advanced directives, irrevocable trusts, all of these things that kind of elevate that planning from a foundational standpoint to now let's take it to the next level and provide some additional protection based on your needs and wants. Powers of attorney. We can never have a discussion of the importance of planning without discussing the most important document you can have, which is a good quality elder-focused power of attorney. And then we're going to talk about Medicaid planning and transfer rules. Now, when we say transfer rules, we're mostly talking about gifting. People often have a ton of questions about gifting. How does gifting factor into becoming Medicaid eligible? How can I protect my assets? And we will talk about that as well. So why do I need an elder law focused estate plan? So I kind of always say, and it's a little cheesy to say, but I will say that we as elder law attorneys are like estate planning attorneys on steroids. What does that mean? It means that we do all of the same planning that an estate planning attorney does. So we do your wills, your trusts, we do the tax planning. We want to ensure that your assets pass on to your heirs with as little cost and as administratively efficient as possible. But we also really focus our plans on what happens if you get sick and need nursing home care? Because the reality is that nursing home care is tremendously expensive. The average cost is almost $13,000 per month, as you will see at the bottom of this slide. Okay, and there's very little insurance that actually pays for the cost of that care. So if you are one of the 70% of people who turn the age of 65 or greater, and you have a 70% chance of requiring that very expensive level of care. And if you do nothing to plan for it, you are going to put what you have accumulated over your lifetime, your nest egg, your life savings at risk. The average length of stay in a nursing home is approximately 3 years. Oftentimes, prior to an actual nursing home admission, someone's also spending some time in assisted living. But if you just follow the trajectory of just nursing home care, you're looking at nearly $500,000 that your portfolio is going to be depleted or decreased because you need that level of care. And these numbers don't take into consideration all of the informal caregiving, right? When a child comes in, quits their job, helps to pay for things that you need if you have to move to that assisted living level. So really, if we really calculated those figures accurately, it could even look like double that number. Okay, so very important for you to be aware that long-term care is tremendously expensive. Colleen, did you want to jump in here since you're online here?
Sure, sorry.
That's
I was
okay.
muted here. Sure, you want me to pick up from the next slide?
Sure.
Okay. Can you?
This one, making benefits. This is the one we're on right here.
Oh, okay, sorry. So in order to fund your long-term care, we need to seek what sources are available to help us pay. Medicare is going to cover a very short period of time. So we have a 3-day hospitalization and are discharged within 30 days to a skilled nursing facility for physical therapy, occupational therapy, speech therapy. Medicare will pay. Now, as a general rule, that's going to be 20 days paid in full, and days 21 through 100 are going to have a copay associated with them. Now, everybody's individual Medicare Advantage plan or Medigap policy could be different. So some folks may have a different copay. They might pay days 10 through 20, or pay starting on day 80, or it could be different. But there's going to be some coverage, but no matter your policy, no matter your plan, the coverage is going to be limited, okay? At some point, you're either going to stop continuing in your skilled therapies, okay? So at the point that the facility decides that the therapies are no longer working, or they're not going to continue to enhance your continued recovery, that they can stop. And when they do, so does the payment. Or you're going to get to 100 days. So either way, Medicare is going to stop at some point. Private pay. So, right, we can all write that check, and that's all what we want to do. We're here in the business of trying not to private pay as much as we can, so that we're limiting what personal assets a family has to exhaust prior to being able to get skilled therapy. Or I'm sorry, to get the coverage at the nursing home. Long-term care insurance. Some folks are fortunate enough to have long-term care insurance. Often people have waited too long and they're either too sick, or it's become too expensive, or if they could afford it when they were younger and healthier, they can't afford it now that they're retired and on a fixed income. So most policies too are going to have some sort of cap. So it's either going to be a dollar figure. So after you get to $300,000, it stops, or maybe after 2 or 3 years. So typically, although it's helpful, we still have to do something else, because it may not even cover the full cost of care anyway, okay? Medical assistance, so that is our largest payer, both nationally and in the Commonwealth of Pennsylvania, the largest provider of long-term care services and supports. And that's where we're going to seek most of our benefits, where we're helping guide families to trying to achieve eligibility to get that long-term care payment from medical assistance. And veterans benefits. So there are all different kinds of veterans benefits, and VA healthcare benefits, and nursing home benefits, assisted living, home care benefits. But there is the pension benefit as well that a lot of people take advantage of. The veterans pension benefit is a cash assistance program available either to the veteran or to their surviving spouse, that they can receive a cash payment in order to help defray the cost of their care. Aid and attendance is a rating that you can receive on top of that benefit to give you extra money for folks who need the help of somebody else to attend to their activities of daily living. So that's going to be most of our people who are living in facilities. So those are options that we have. Our foundation of our estate plan is going to be our last will and testament. It's the legal document that says who gets our stuff, right? So at its most basic, we are just saying, who do we want to be in charge? That's our executor. And where do we want our stuff to go? So the executor, and we often request that people try to think of at least one alternate too, in case our executor has passed away by the time we pass away. Pick one person and a backup to be able to handle your affairs, pay your bills, pay your taxes, make distributions out to your heirs. And how those assets are to pass. Is it specific bequests of certain dollar figures, percentages, maybe just as simple as to my kids in equal shares, right? So how are assets going to pass? If you do have minor children, we want to make sure that we're taking into account that we would be providing a guardian for that minor child. But coming up with our plan, if we are not if, but when we pass away, how do we see things passing? And it doesn't have to be overly complicated, but we want to make sure that we have those wills in place, because without them, then the state gets to say who gets your stuff. It's not that the state gets your stuff. I mean, some people think that if they don't have a will when they pass away, the state's going to get their assets, and that's not true. But the state says who does and in what amounts, and that might not be what you want for yourself.
All right, so how and what does a will actually control? For a lot of people, this is very confounding and confusing, because we all put this will kind of like up on a pedestal, that it absolutely controls everything that happens to your stuff when you pass away. But the reality is a will is only a component, and often controls so much less than you actually think. And the reason for that is right here on this slide. Anything you jointly own with another person automatically passes to the surviving joint owner. So if I jointly own a bank account with my sister, but in my will, it says everything goes to my husband, that bank account goes to my sister. The ownership controls over what is written in your will. Anything I have a beneficiary designation listed on. So a life insurance policy, retirement account. If I only have one child listed as the beneficiary on my retirement account, but in my will it says everything goes to my 2 children in equal shares, that beneficiary designation is going to control, and it's going to go to my 1 child, not to both of my children. So your last will and testament only controls those assets that are in just your name alone, with no joint owner and no beneficiary. Okay, and that's really important for people to understand, because they come into the office and just say, I want a will, and why do I have to tell you about the assets I have? Why do I have to disclose what beneficiaries and ownership I have? And the reason is because we need to make sure that we have a comprehensive understanding of how your estate is actually set up and what is that will actually going to control. So we see nowadays all of these things online and on the TV where it says, hey, create your own will for $99. The reality is that a will is just a piece of paper if it's not prepared in conjunction with a very solid understanding of what your assets look like, because otherwise it means nothing. Now, if you pass away without a will, Pennsylvania has a schedule as to how your assets are going to pass. And this is particularly important for spouses. Oftentimes spouses assume that because I'm the spouse, I don't need a will. But the reality is Pennsylvania law doesn't work that way. It does not automatically all pass to the surviving spouse. It will be divided with your children if you don't have a will that specifically directs everything to your spouse. So it's, again, really important to have a will and to understand what that will actually is going to accomplish for you. Now, the one thing that works a little differently with respect to ownership is real estate. In Pennsylvania, there are 3 ways in which you can own real estate. Number 1, as spouses, you own real estate as something called tenants by the entireties. And that simply means that my husband and I own our primary residence as husband and wife tenants by the entirety. So if I die, this property automatically vests in my husband's ownership. We don't have to probate the will. We don't have to administer the will. In fact, we don't even have to do a new deed that will remove my name from the deed. He can keep my name on the deed. It's no problem. Okay. Now you can also own property as joint tenants with rights of survivorship. So if Colleen and I owned a lake house together and we had the title as Colleen Brakovich and Christine Brown Murphy as joint tenants with rights of survivorship, that means that when I die, that property automatically vests in Colleen's ownership. It doesn't matter what my will says. Even if my will says everything goes to my husband, because we own that property as joint tenants with rights of survivorship, Colleen becomes the 100% owner of that property. Or Colleen and I could own that lake house as tenants in common. Now, tenants in common is when we will look to the will of the owner that has died. So in that same circumstance, Colleen and I own this lake house together. I die, but we own that property as tenants in common. That is when we will actually look to the will, to my will, and decide who's going to get my interest in that property. So it's really important, if you own property with more than one person, pull those deeds out, take a look. How do you own that property? Because you may intend for it to actually pass to the surviving owner, but maybe you actually have the ownership listed on the deed as tenants in common, or whatever your intent was. You want to make sure that what you intend to happen actually does. Okay? All right, so understanding asset roles, and I kind of just went through this actually, so I'm not going to even go back through this, but basically saying that beneficiary designations control. So any asset you have, if you have beneficiaries listed, we don't even look to the language in your will to determine who gets that asset. The beneficiary designation controls. So some of the things, because again, we are elder law attorneys and we always elevate our documents to address, well, what happens if down the road, one of us needs nursing home care? Well, we always include, we could include a provision in the will. So for instance, I'll give you an example of a case I'm working on right now. Husband is in the hospital, wife is in the nursing home. We do believe that husband is going to get better and come back home. Now, on Friday, I'm going to go to the hospital and I'm going to take 2 things with me for the husband to sign. He's going to sign a new deed to his property. He is going to become the sole owner of that real estate. And we're also updating his will. And his will is no longer going to say, if I, husband, die first, that everything passes to my wife. Instead, I'm going to put a special needs trust provision in his will. And what that's going to say is, because my wife is in a nursing home and we are working and going to get her eligible for Medicaid, if husband dies first, we do not want these assets to pass back to the wife. Because if they do, she will lose her Medicaid eligibility, and the assets would then have to be spent down before she could attain eligibility again. So all of these steps we're taking for asset preservation planning will be lost because now she simply inherits those assets from her husband. So instead, in his will, I'm putting a special needs trust. And what it says is, if husband dies first, these assets are going to go into this special trust for the wife. This special trust allows the wife to continue and maintain her Medicaid eligibility. So she can receive these things, but because they're going into this special trust, she doesn't lose her Medicaid and we don't lose the assets. When she dies, that trust is dissolved and paid out to her 2 children upon her death. So that's one thing. We always want to take a look and say, do we foresee one of our spouses needing long-term care? If so, we don't want to ignore it. We want to address it in the documents. Another option sometimes we take is, instead of including the special needs trust, we will just choose to disinherit the spouse who's sick and in the nursing home. And this is all a part of a discussion we have with the family to decide what do they think is best for their family. So that's another option. It's always just part of a very important conversation to ensure that all of this planning that we're doing doesn't become undone because of an unforeseen circumstance. And then on top of all of that, we need to now go back to all of those assets that husband has that he gets to keep while his wife is on Medicaid. We need to remove the wife as the beneficiary. We can no longer leave her as the beneficiary because if she is, she's going to lose her Medicaid eligibility. So now we direct those assets into that special needs trust for the benefit of the wife. All right, so, a special needs trust is really tremendously important for anyone, whether it be a child, a grandchild, a spouse who is the recipient of government benefits. So maybe, you have a grandchild who is born with autism or some intellectual or physical disability that really they depend on government assistance, benefits, and programs to keep them in a positive and good standing. You want to ensure that there's nothing in your estate plan that's going to cause them to lose their to lose their benefits. A special needs trust is key with respect to that. So if you have a child or a grandchild who has any kind of special needs, your will needs to have special needs trust language. It's tremendously important. Do not ignore it. Also, don't disinherit that grandchild simply because they have because they have a disability. A lot of times people think that that's the way to plan. It's not. If you have a child or a grandchild or a spouse who has a special needs, we need to address that in your plan by directing their inheritance into a special needs. If you don't truly want to disinherit that child, we shouldn't. Because when you choose to disinherit them and you think, oh, well, my other kids are going to take care of that child, it's going to have all kinds of adverse tax consequences. There's no legal obligation. There's a smart way of planning and a simple way of planning. And the simple way of planning often is not the smart way of planning. Okay? Colleen, you want to take over here?
Yes. Okay. I unmute myself again. All right. So as Chrissy was touching on before about asset protection trusts and ways to try to help families qualify for Medicaid, the asset protection trust is really like the one tool we have in our toolbox that's going to be able to help our families protect and preserve assets. Any trust at, the basic level is just an agreement about how assets are used, for what, who can touch them, why, and in what amounts. But when we're doing an asset protection trust for Medicaid purposes, the rules and restrictions that we're putting around the money or the assets, or that these assets are not available to us, and we're not available to use them to pay for our long-term care. And that's what gives us that protection, so that when the Department of Human Services is reviewing what assets a couple or an individual has in trying to get eligible, they say, oh yeah, look, on the face of the agreement, it says we're not allowed to touch these assets. We can't count them in trying to assess somebody's net worth. So it offers us that protection. The other protection that it offers is that because those assets will bypass probate and bypass the estate administration of the individual, they are not going to be subject to Medicaid estate recovery. Okay, so getting eligible for Medicaid in the first place is part of it, but then once somebody does sign up for Medicaid, they agree to a program called Medicaid estate recovery. And that's where the state's required by federal law to try to get paid back out of the assets of the estate of the individual after they've passed away. So the state's keeping a tab of what they've paid out in room and board and prescriptions and doctor's visits, hospitalizations, and they expect to try to get paid back. So by having assets held in an irrevocable trust, we are keeping those assets from being able to be recovered against in the end. So even assets that maybe are otherwise excluded or don't have accountable value, like the family home or, business properties, or, if we can keep them out of the estates of the individual after they pass away, we're going to keep Medicaid's hands off of them, or, the Commonwealth of Pennsylvania. So it functions for two purposes. One, to, get us eligible in the first place, and two, to help protect and preserve those assets from being recovered against in the end. So it helps in both of those. Now, with regard to the trust, when you do apply for Medicaid, Medicaid does audit those 5 prior years to see what did you do with your money, how did you get to where you are today, and you're asking us for our help. And if you have transferred assets into an irrevocable trust and now done something intentional with them to make them not available to help pay for your long-term care, the state is going to impose a waiting period, basically. They call it a penalty, but an ineligibility period based on the value of what was given away. If those assets have been transferred more than 5 years prior to the application for Medicaid, well, when the state does that audit, they're not going to be part of the audit. So they're not going to be part of the eligibility calculation, and the state's not going to impose that waiting period. So in a perfect world, we can create this trust more than 5 years before somebody needs nursing home care, and then those assets are 100% protected. We don't live in a perfect world, so that doesn't always happen, but that's one of the main places where we're going to use these types of trusts. The other is for maybe a single individual who, is in current need of care. So the need is now urgent, but they still have assets. They still have too much money and they can't qualify for Medicaid. It gives us an opportunity to maybe take some of those assets that they have, intentionally retitle them in the name of this trust, knowing that we're going to have a waiting period, but we also then just have to calculate how are we going to set money aside to be able to pay through that waiting period. So basically taking the assets and being able to divide them for two purposes. One pile that we're going to get to protect, and one pile that we unfortunately will have to use to pay for care in the meantime. But at the end of the day, we will be able to protect some assets. Okay, so I think I kind of went over this already, but the assets are not counted as available resources when it comes to, and that happens immediately. Sometimes people think the trust doesn't go into effect for 5 years. That's not true. The trust is effective, when the asset transfers title, the asset is now no longer a countable resource. It's just that where has that been on the 5-year spectrum as to whether or not there's an impact, okay? So with regard to family home, so as I mentioned, the family home is not really a countable resource. They don't kick you out on the street. They don't make you sell it. They don't count the value of it. But it can be recovered in estate recovery for somebody who's been on Medicaid. So often you'll hear stories of people saying, oh, I just want to put my house in my kid's name so the nursing home can't take it. Okay. Well, there's a benefit to using the trust in lieu of giving the house to your child. And it really comes down to taxation. So in the example that Christine's provided here, we've purchased the home for $50,000 in 1965, and today it's worth $150,000. So, mom or dad's basis in it is $50,000. We have $100,000 of gain. Okay, so the way that those taxes are calculated are different, whether that child has been given the property or whether they have inherited it. If we give the property to the child, okay, the child has inherited it at $50,000, or I'm sorry, the child has received it at $50,000. Their basis is $50,000. When they sell it at $150,000, they have to report $100,000 worth of gains, okay, assuming that that house is not the primary residence of the child. So, that could be $15,000 in capital gains taxes if they pay at the 15% rate, okay? If we use the trust, the child doesn't actually own that property, okay? The grantor, when we use a grantor trust, so mom or dad, they still retain the taxable ownership of that property, okay? We've restricted how it's being counted for them, or restricted their ability to use the equity value in the house, but it's still theirs. The IRS still considers it to be theirs. So it's sitting in the trust. So we've gotten it out of mom or dad's name for purposes of applying for Medicaid, but the house doesn't actually vest in that child until mom or dad's death. So they've inherited it. When you inherit appreciated property, you get what's called a step up in tax basis to the current fair market value. So if the kids get that property at the current fair market value at $150,000, they sell it at $150,000, they have no capital gains tax. Okay. Now they do have the Pennsylvania inheritance tax that they've inherited at 4.5%, but that's going to be a much lower tax than the $15,000 that they would have paid in capital gains taxes. So we've met our burden of protecting the house for purposes of Medicaid, but we've given the kids a lower tax bill, which is going to be preferable to them.
Yeah, it almost never makes sense to give your home to your children. And far, far too many people do it. You're creating a really significant tax bill for your kids. Anything that has really appreciated in value, meaning that at the time you acquired it, it was X amount of dollars. And because you've retained ownership of it over an extended period of time, it's really increased in value. You almost would never want to give that to your children during your lifetime. For the most part, if you're looking to protect the asset, it's going to make so much more financial sense to put that property or asset into an irrevocable trust and allow your children to get that step up in cost basis when you pass away. Makes much more sense for them to pay Pennsylvania inheritance tax at a 4.5% inheritance tax rate rather than that capital gains tax rate of 15 or 20%. So don't do what your parents did, because everybody's like, oh, my parents did that. They gave us their house and this is just what we did. Your kids won't be happy down the road when they get that capital gains tax bill. I know I wouldn't be. All right, so revocable living trust. Now, this is different than the irrevocable trust. And a revocable living trust does nothing to protect your assets from long-term care. But protecting your assets from long-term care is a choice, meaning that some people say, hey, we've accumulated this money, and if one of us needs care or both of us needs care, this is our money and we'll just spend it on the cost of care. And that's totally fine. It is a choice. But if you are that person who does want to protect assets from long-term care, you're going to want to be thinking about an irrevocable trust, not a revocable trust. Now, a revocable trust certainly has its purpose, and we use them a lot, but it has its purpose more so in the realm of just traditional estate planning. So for people who want to avoid probate, or maybe have complex family needs, meaning maybe you have children from a prior marriage or on your second marriage. You have complex or diverse asset holdings. Maybe you have property in more than one state. You have an ownership interest in an LLC. Maybe a spouse doesn't handle money well, or one of the spouses or individuals has a disability. There are reasons to utilize a revocable living trust, but deciding whether you want to have a revocable living trust or an irrevocable trust is really going to depend on your financial circumstances. Are you self-insured, meaning that long-term care planning has no place because you have too much in the way of assets and you are just self-insured, you will pay your way? Again, are you that person who just, it's not, hey, it's your money, you'll spend it if you need long-term care, preserving the assets isn't really a concern. Otherwise, we're looking at an irrevocable trust if those are your concerns, okay? Durable financial power of attorney, one of the most important documents you can have. One of the things I will point out is that they are not all the same. An elder-focused durable power of attorney is 100% the type of power of attorney you should all have. If you pull out your power of attorney and you look at the language and it has little one-liners, your power of attorney is likely insufficient to address a long-term care need. Okay, you really need to make sure you have a comprehensive document that gives certain rights. One of those certain rights is the ability to create an irrevocable trust. If your power of attorney says that your agent has the ability to create a trust, under Pennsylvania law, that means your agent has the ability to create a revocable trust. Well, a revocable trust does not give your agent any ability to protect your assets if you need long-term care. You want to make sure that your spouse has the ability, number one, to make decisions for you. So many people think that just because you're spouses, that you have this automatic right to make financial decisions. You do not. Some of the biggest crisis in our office is when somebody is incapacitated and a spouse who's healthy can't access the finances to pay the mortgage, support the children, begin planning to get the spouse who's ill on Medicaid, and they're depleting and spending $14,000 per month in the nursing home, and they can't access the money because they don't have power of attorney. By far the most important document you can have. If you become incapacitated without a power of attorney, we are now going through a guardianship, which our office does. But a guardianship is when you become incapacitated, you don't have a power of attorney, and now a court is going to determine that you no longer have your civil liberties, essentially. You no longer have the right to make decisions for yourself. And the court is going to appoint someone or an agency to be the individual that is a guardian for you. You don't get to choose. So that's the importance of a power of attorney, is you get to contemplate and decide who's the person that's best equipped to make decisions for me. You put that person in place rather than a judge who's just reading, your file on some paper and testimony from a doctor. Really important to make sure that you plan for yourself and don't put yourself in a circumstance where your family's now paying thousands upon thousands upon thousands of dollars for a guardianship, just when a POA for less than $1,000 would have put your family in a place of security. Okay. Now, a durable power of attorney does not require you to be incapacitated. In fact, probably 90% of the time when somebody is acting as an agent under power of attorney on behalf of someone else, the person's not incapacitated. Oftentimes, power of attorney is put in place because sometimes just as we age, things get more difficult. Or maybe we just have a period of incapacity, right? We're in the hospital. We're not able to address our own affairs. We can't pay our bills. Maybe we had a spell, an illness spell, that we can't take care of these things. A power of attorney is going to be able to do those things for you. One important thing that is different from a guardianship, a power of attorney does not take any power away from you. You are still in charge, okay? So your agent under power of attorney can't say, well, too bad, I'm power of attorney and you're going to leave your house, mom, and I'm putting you in a nursing home. That's not what a power of attorney does, okay? Now, a guardianship can do that. So that's important, again, why you want to make sure you have a power of attorney so that the people you trust most can make those proper decisions for you. Sorry, I can't get this thing to swap for me. And I think I've already talked about this a little bit. The quality of the power of attorney matters. It just absolutely does. Do not think you're going to go get one. I mean, sure, you can go get one online and download it. You are going to find that your agents are in a position where they cannot advocate and do things to protect your assets. Financial institutions take power of attorney extremely serious because they are taking instruction from an individual that is not you. And so they want to see very explicit language in that document that is going to protect them from doing things that could hold them liable for acting inappropriately under the direction of an agent under power of attorney. So quality of the power of attorney is tremendously important. You want to get an elder-focused power of attorney. Colleen, you want to do this one?
Sure. So, like the durable power of attorney for finances, you also want to appoint a healthcare decision maker. Okay. So in Pennsylvania, we have the right to appoint somebody to be able to stand in our shoes and make decisions for us with regard to our care. Now, that's probably used a little bit less frequently with regard to decision making than perhaps a financial power of attorney does, because there are situations where individuals, can't get out, they can't get to the bank, they have difficulty getting on the phone with their insurance company, but they're perfectly fine to be able to communicate to their physician about what they want as far as their course of treatment is concerned. But the healthcare power of attorney does allow for you to appoint somebody else if you would become incompetent or incapacitated to be able to make healthcare decisions for you. Okay. There's some other benefits of the power of attorney just in, a release for protected health information. So giving your family the ability to get health care information about you, talk to your physician, talk to those who are on your care team to, get access to your medical records and things of that nature as well, in addition to being able to make healthcare decisions for you. Okay. Now the living will goes along with the healthcare power of attorney, but the living will is guidance that you are giving to your family about how you want them to decide for you when it comes to the end of your life. Okay. And the living will is only going to take effect when the person is incompetent, and they can't ask those questions of what we call the principal, the person who's in need of the care. If we cannot ask them those questions with regard to their end of life choices, then we're going to follow the living will. So the living will comes into play when you are incompetent, have an end stage medical condition, are permanently unconscious, or have an irreversible condition leaving you unable to care for yourself. Okay, so that document will then take place, to be able to give guidance to your family. That's okay. To be able to give guidance to your family about how they should decide for you if they are tasked with having to make those unfortunate calls with regard to your long-term or life-sustaining treatment. Okay. So we touched on this a little bit, but understanding the Medicaid look back. So as I mentioned before, the state's going to audit 5 years prior from the date that you make that application. Okay. So making gifts doesn't automatically make you ineligible for Medicaid for 5 years, but what they do is that they're going to look to see over those 5 years, did you give anything away? So the state's generally looking for transactions in excess of $500 in 1 month. And have you made gifts? So when we file for Medicaid, they're going to ask for 60 bank statements, the 60 prior bank statements, and look for those transactions to try to see, did you give anything away? If you did, the state's going to aggregate all of those gifts, okay, take that total amount and divide it by $421.20. Okay, that's our penalty divisor for this year in Pennsylvania. That's the average cost of nursing home care. So each January 1st, the state's going to release their figures. What's the average cost of care in the state? So what's left over, so we take the amount of money given away and we divide by 421, and the state said that's your period of ineligibility, that's about how much care that would have provided you that you are now asking for our assistance. So we're going to make you wait that period of time, so that number of days. So, if it's $100,000, like in this example, divided by 421, that gives us 238 days. That means when you are otherwise eligible for Medicaid, you then have to wait 238 more days before the state will offer their assistance. Okay. But why that's really critical is that when you're otherwise eligible for Medicaid, it means you're in the nursing home and you're out of money. And now that 238 days gets applied. So we really need to know how we're going to try to pay through that period of ineligibility. Otherwise, the nursing home is going to not be paid. They're not going to be happy. The person might go out to the hospital and not be welcome back because they aren't paying their bill. So it's really something that we need to plan for if we know that someone has made gifts. Okay. And the rules are different. We don't have to go into great detail, but the rules are different with regard to what the IRS says is a gift and what you can do and what Medicaid says. So for this year, the IRS says you can give away $19,000 per person per year, and it doesn't count. Okay, which is true. So it doesn't count for IRS rules or with regard to federal gift and estate tax purposes. Okay. If you go over that $19,000 per person per year this year, it just goes to reduce your lifetime exemption, which right now is $15 million. So the folks that we have who are planning for the possibility of Medicaid are not usually the folks who are worried about making these tax gifts because they're trying to avoid the federal estate tax. Okay. For our Medicaid families, anything over $500 in 1 month in total is a gift. So you got 5 kids and you give them each $100 in December. Well, you've made a gift. Okay. Or I guess 501, it would have been a gift, but that would be exempt.
It's a you made a gift, but it's a permissible gift.
But it's a permissible gift.
Yeah.
It's not counted. But as soon as we get to $501, then we're going to start counting gifts. Okay, so the state's going to look back to see, did you make more than or make any gifts that were in excess of $500 in total in 1 month?
And they do. I mean, they go through and they
Yes.
audit those statements. They go through, they look for every penny. It's very frustrating, but they do. And they ask for verification, so you have to prove. All right, so
Okay.
some of the exceptions to the Medicaid transfer rules, meaning that, okay, if you make these gifts, Medicaid's going to not penalize you. They're still going to be gifts, but they're not going to impact your eligibility. So transfers between spouses, as I told you this week, I'm going to be heading out to St. Clair Hospital with the new deed to the property of my client, removing the wife's name, putting it in just the husband's name. We are permitted to do that because it is transfers between spouse. That is an exempt transfer. If you have a blind or disabled child, you are permitted to make transfers to that blind or disabled child. However, you also have to be very careful. Is that blind or disabled child a beneficiary of any kind of Medicaid or government benefits? If so, you need to create that special needs trust I was talking about earlier in order to make transfers to that child, who is receiving government assistance. Or if there is, you can create a trust for the benefit of any disabled individual that is under the age of 65. So there are permissible transfers for individuals who are looking for Medicaid eligibility. So there are certain exemptions in order to allow those transfers to be made without there being an impact on eligibility. All right, so we're going to give you a quick overview here because I think we might be going a little long here, and we want to give everybody else a chance to talk. So this is a quick case study here, okay? So this is when diagnosis triggers action, right? So in this circumstance, John is 72, and he was recently diagnosed with early stages Alzheimer's disease. His wife, Mary, 68 and healthy. They own a home valued at $250,000 jointly, have $600,000 in non-qualified investments. Mary has a $200,000 IRA, and John has a $300,000 IRA. This brings their total assets to about $1.35 million. This scenario highlights the critical importance of early repositioning to protect their financial assets for long-term care and ensure that Mary is well taken care of in the event John needs care at some point in the future. So what do we do at this point? Because we're so far out, we would have one of two choices. We could create an irrevocable trust and transfer the home into the irrevocable trust because likely going to be able to make it through the 5 years since John just received this diagnosis. By putting that property into the irrevocable trust, not only does it protect the assets from John's nursing home need, but it also protects the possibility of Mary ever needing nursing home care in the future. So the home is protected for both of them. With respect to IRA beneficiary changes, John's IRA would be the first thing that we're going to go ahead and begin to spend down. So as John's needs increase, we're going to begin spending down John's IRA because it is a countable asset. Okay, what we are going to do with respect to Mary's IRA is list those children as beneficiaries instead of John. Okay, now Mary's IRA is completely exempt if John needs nursing home care. They do not count the retirement account of the spouse who is healthy and not in need of nursing home care. With respect to the qualified or non-qualified, so non-retirement accounts, we'll have a very hefty discussion with the family to decide how much of those assets do they want to transfer to the irrevocable trust for protection and how much do we want to keep outside. And then we're going to go ahead, update their powers of attorney. John is not going to be Mary's power of attorney. We're probably going to go ahead and defer that responsibility to one of their children. And then we're going to update and make sure that John has an elder-focused power of attorney with Mary as the primary decision maker. We're also going to then update Mary's will. And Mary's will is going to say, hey, yes, I'm the healthy one right now, but we all know things happen. And if I die first, these assets are either going to go to my children and I'm going to disinherit John, or if Mary's not comfortable with that, we'll create a special needs trust in Mary's will and direct assets into that special needs trust. I'm going to actually, Colleen, you want to go through that last case study and then I think we're done there.
Yeah. Okay. All right. So this is the Millers, okay? When long-term care insurance changes everything. So we've got Robert, 68, and Susan, 65, both happily in their second marriages and enjoy good health. Their assets include a primary residence in Pennsylvania valued at $400,000 and a vacation home in Florida worth $300,000. Additionally, they hold $500,000 in combined investments and retirement accounts, bringing their total assets to $1.2 million. Crucially, both possess comprehensive long-term care insurance policies that'll provide lifetime benefits. So given that their long-term care costs are fully covered, their estate planning priority shifts to minimizing the administrative expenses and ensuring their assets pass smoothly to their respective children from their first marriages. So for them, a revocable trust plan is ideal, offering robust framework that addresses their unique multi-state and blended family needs. So we're avoiding doing probate in both Pennsylvania and Florida. So with the estate administration being able to be handled in one state, we're eliminating the need for separate probate proceedings, which saves time, a lot of expense, and complexity for their heirs. The trust document is going to provide precise instructions on how assets will be distributed to Robert's children and Susan's children, preventing potential disputes and ensuring their wishes are honored. So that's critical in any family, but especially with a second marriage. We might have really specific, bequests out to individuals based on assets that were brought to the marriage, assets accumulated during the marriage. So we want to make sure that those are honored. Lifetime management for incapacity. So if either Robert or Susan become incapacitated, the successor trustee that's been designated can seamlessly manage their assets without court intervention, ensuring their financial affairs will continue uninterrupted. Okay. A well-structured trust can help reduce potential estate taxes if they would be individuals who have to worry about the federal estate taxation, and generally would just lower their administrative fees compared to what the costs are with regard to probate proceedings. Protecting the surviving spouse and preserving the inheritance, the trust can be designed to provide for the living spouse's needs while safeguarding the principal for their respective children, balancing the immediate support needs of their spouse with their long-term inheritance tax goals of getting the money to their children. So very different situation. Long-term care costs are not their concern. They have pretty much self-insured. They're going to be more concerned about control and how assets are going to pass to the next generation.
All right, well, that was good job, ladies.
Oops, sorry.
We have not had any questions throughout. I did want to give Ari the opportunity to talk about WeCare, and I know he has a video. Now that hopefully everyone's still awake after that presentation. And if we want to, that's information on how to get a hold of both our attorneys at our firm and then also WeCare, their website, if you want some information. And we can stop sharing and maybe allow Ari to share.
Thank you,
And all the Lorries.
Lorries, thank you, Carrie. First, I thank you, Christine and Colleen. Really, being in healthcare for over 20 years myself, I want to tell you this was riveting for me. The case study at the end did remind me of my 9-year-old's math homework last night. So I did appreciate that opportunity to fall back into that role. But truthfully, time and time again, in my career during that span, I have seen the difficult and complex scenarios that families, loved ones, residents go through when they are admitted to a long-term care setting. Information like this is so valuable because in many ways, healthcare planning, long-term care planning, and estate planning, it's not isolated in parts. They all intersect. And when we see a resident coming in having these things organized, it's a breath of fresh air for us too. When we know that someone's coming in our doors, like, okay, hey, yeah, they've already done these things. Okay, great. That means they're aware of it. They know what they need to know because we want to make sure that we can provide them the maximum amount of care for as long as they need it during their stay there. And we always get, we feel the pain that they have when they're looking at it from a financial piece, whereas there is government support for the services that we can provide. And when they clean this up so nicely, it really makes everything so smooth. I know as we wrap up, I just want to also thank people. Carrie, I want to thank you for helping put this together along with Lori, my assistant, and all the many Loris, but also Maria from the Squirrel Hill Urban Coalition. Really appreciated being able to have an idea, have a vision for something and see it come to light today. So thank you all so much. And just to wrap up, we just wanted to share a little video that we created for WeCare, and of course, that touches on all of our communities in the greater Pittsburgh area. So on that note, to wrap up, I hope you find this video.
We do have two questions that
Oh.
I'll do after the video.
Oh,
Do the
okay,
video and then I'll
excellent.
address them.
Fine. So Gary, I'll let you pick it up from there. But thank you all so much for participating and enjoying this presentation.
Can't hear it.
Lori, the audio might be stuck. If you want me to share it from here. Lori? One of Lori's? Lori, I might just share it from here because I don't know if you're hearing it. I'm gonna take it. Sorry, everybody. We're gonna do this. Is that better? Working?
I can't hear it.
WeCare's mission from day one
There we go.
to create a healthcare organization that we can be proud of for our families, proud of for our friends, for our loved ones. Healthcare community means each of our facilities represent the communities that they were within. Having a facility nearby that people can rely on for rehab, for a place to call home when they can no longer live at home, that's what it means to be part of the community. A place that you know when you're older, or you know if you have a loved one, like, hey, my friends will be able to come visit me. My family can see me, and I can also be in the community that I have been living in. And to me, making sure that we have facilities that can continue to be there for their own communities.
Our reputation is really strong. We do everything in our power. A lot of that is bringing them into a community that's positive, that's fun, where they know people really care about them.
Our primary focus is always going to be making sure that our residents have the best care that they can get, and our staff have the best resources they need so they can continue to work with us and be proud.
The owner has been in there and they came in and served ice cream. They walk the floors. They meet the staff. They talk to them and they make them feel included in everything. And I really like that. This is a wonderful company. We have a management team that will meet every need and goal to our best ability. Why? Because we care, because we love, because we have the heart for nursing.
The staff are very diverse. They listen to my needs. If I need something, they help me as much as they can. And you see, I have some that I consider not more than staff, like friends. They're very friendly.
We want to be the best that we can be, the compassionate, caring, taking care of these residents appropriately, making sure they're comfortable, making it a home-like environment for them. And if they're coming for short-term rehab, making sure that they have the best therapy to get them the journey home begins with WeCare.
We've earned this spotlight. We've earned being a center for care for Pittsburgh, Pennsylvania. We're here to stay. We're here to build a continuity of care for this community, for the surrounding communities that will last, that will be there for your loved ones and generations thereafter.
I love that.
Yeah, awesome. Thank you so much. All right, so quickly, first of all, thank you so much to WeCare and Ari. I've really enjoyed this whole process of planning with you and all the Loris. And question for the lawyers. So here's our two different things. Please recommend a book to read to educate oneself on this topic before making an appointment. We have a great website with a ton of information. We have a resource hub that has articles, videos. We also have a publications page We are in the process. Our web developer is uploading all new versions of the books updated for 2026. All the books are on there now, but within the next week, they will all be updated.
I'd wait the week because really we worked really hard on updating all of this material. So tons of information if you want it. In about a week, all of the new versions of these books will be online. So maybe next week, check out our website, zachbrownlaw.com.
And they're all free and downloadable. And then second of all, a POA versus guardianship. You mentioned that the POA cannot override your wishes. Can you say more about that and give me some examples? If I'm ill or unconscious, how would anyone know what my wishes are? And first, I think we'll talk about how a power of attorney is different than guardianship.
Yeah. So a POA, someone is basically stepping into your shoes and making decisions for you. So to the extent that you have put specific language in the document, it is their responsibility to follow the document and what you have written in that document and for them to act within your best interest. As a guardianship, basically you no longer have the right to make those decisions. So they are truly being the decision maker for you. What a power of attorney cannot do is overrule or override your decisions. So if you decided as an individual that you wanted to move into a $5,000 a month apartment and your child thought you should only move into a $2,000 a month apartment, your $5,000 a month apartment is what would stand because you are the decision maker. They cannot pull that decision making away from you. Guardianship, again, is you don't ever want to have to go through a guardianship if you don't have to. Because again, a court is actually taking away your civil liberties. So even if you regained capacity after a guardianship was instituted, we need to then go back to court and have the guardianship taken away. Also, in addition to guardianship, it's an annual requirement. Colleen, you might want to speak a little more to it. I think, did you just deal with the guardianship this morning or was that something?
I did. I was in court this morning for
Yeah.
guardianship. So yeah, I mean, power of attorney is much more flexible with regard to just using your judgment, acting in the best interest of the individual. If you are acting as the guardian, the court is overseeing what you are doing. So you are required every year to account for every single penny that you spent on behalf of that individual. And you're going to, when you have your guardianship instituted, you're going to talk about a general scope of how you're going to be spending the person's money. If you want to go outside that scope, you have to go back to court and ask for a petition for allowance for X, Y, and Z. So this person wants to go to this camp this year that's available to them. Well, it's $3,000. So we have to go and ask the court's permission. This is outside of the scope of their every month, every regularly recurring monthly expenses. So we need to ask the court's permission. And then the court gets to decide, well, is this a good use of the person's money or maybe not because they don't have that much left and we should really be trying to stretch it out for their true needs of rent and medical expenses versus allowing them to have this, other fun experience or spend the money on a new TV or, new computer for them instead. So you're losing that, although you have lost the ability to, have your civil liberties and make decisions for yourself, you're also giving up the opportunity to have somebody use their own discretion about how to use your money or their own discretion about what's a good place for you to live. You're leaving it up to the court to decide. And at the end of the day, they're probably going to side with what's going to make this money stretch the longest so that we can provide for the true immediate needs of the individual without relying on government assistance. So you really are giving up rights that somebody else would have to be able to decide how that money is used, where we live, and what kind of quality of life we have.
Which is why it's so important to have a power of attorney. And just to circle back for healthcare, I know we talk about a lot of times, if you have your agent appointed under a healthcare power of attorney, as long as you're able to communicate what your healthcare wishes are, they will take your wishes over what your document says. So just circling back on healthcare power of attorney as well. But it's why we say it's the most important document you can have because you don't want to have a guardianship.
Exactly.
That's it for the questions right now. So thank you so much to everybody. We really appreciate it.
It was wonderful. Ari and everyone, thank you so much for having us. We really enjoyed it.
Yes, thank you.
Partnership.
Bye-bye. Have a great day, everybody. Thanks. Bye-bye.
Thank you.
Bye.